Welcome to the Estate Blueprint, Planning Your Future with Tom Begley.
Hello and welcome back to the Estate Blueprint with attorney Thomas D. Begley III, founder of Thomas D. Begley III LLC in Moorestown, New Jersey. Tom is a certified elder law attorney with more than 35 years of experience helping South Jersey families protect what they've worked for through estate planning, special needs trusts, Medicaid planning, and probate administration. My name is Kevin Rosenquist. Today we're talking about what happens right after a loved one passes away. When someone's named as an executor, they often have no idea where to start. So we're going to break down what those first 30 days really look like in New Jersey and how to handle them without feeling overwhelmed. Tom, welcome back.
Good to see you, Kevin. Fire away.
Yeah, good to see you too. All right, let's get after it. So when someone passes away in New Jersey and you've been named executor, what are the very first things you should do within the first week or two?
Well, yeah. So in the first couple of weeks, you basically want to make sure that you have the original will. You want to make sure you have a certified copy of the death certificate. And if possible, make an appointment to go see the county surrogate. In New Jersey, it's the surrogate's office, which acts as the place where you go to with the will to probate and get what's called short certificates, which are one-page forms with a proverbial raised seal that allows individuals to conduct business on behalf of the estate. In the state of New Jersey, when you are named as the executor, you're allowed to probate the will. Well, you can file for probate, but probate will happen after the 10th day after death. And the reason the 10 days is there is because just in case somebody finds a later will, which happens from time to time, or make sure you want to get the right one probated. There have been times when the wrong one gets probated. That causes a mess. And sometimes some wills are not valid, or some people want to challenge them, so it provides somebody an opportunity. But if you are the executor, job number one is make sure that you have the appointment set up to go to see the county surrogate to have the will admitted to probate.
Is there anything else someone should be bringing to that surrogate's court other than the death certificate and a copy or on the original will?
Well, you should know the names and addresses of the next of kin. In the state of New Jersey, after a will is admitted to probate, what they're going to want to do is require you from the surrogate's office to send a notice of probate. And notice of probate is a form that's very simple. It says two things. One, on the blank day of November 2025, the last will and testament of Mary Jones was admitted to probate, and Kevin Rosenquist was appointed as executor of the estate. So giving you some work this afternoon. And the second sentence that a copy of the will is available without charge upon request. Now, I think that's kind of a tactic that I think that members of my profession should avoid doing, because really it's kind of like, let me charge for two letters rather than one. So quite frankly, most of us that try to run reputable practices change that sentence to second sentence to read, a copy of the will is enclosed. And that is because everybody's going to ask for it anyway. So in order to get that done, you have to provide the names and addresses of the individuals who are named as the heirs in the will. And if there are individuals named just in a fiduciary capacity outside the executor, that would be a trustee or a guardian, you should have their information. And finally, you're also supposed to have the names and addresses of those individuals that would receive a share under an estate if no will had been prepared and executed. So for example, mom's a widow, she has 4 children, one of them is being disinherited, and even though he's not going to be part of the estate plan, a notice does have to go to him because he would have received if no will had been presented. So you have to get that general information. And then the other thing you should do, because it doesn't take any time whatsoever, is get a tax identification number for the estate. And that's done, you can do that before you even go to the surrogate's court. It takes a handful of minutes on the IRS website. And you need obviously your own Social Security number for the executor, as well as the Social Security number of the person who passed away. Because when you die, your Social Security number dies with you. And at that point, you need to get a tax ID number to kick in so that when you do get the ability to have the will admitted to probate and get those short forms I discussed, when you go to financial institutions to access and create accounts on behalf of the estate, they're going to want 2 things. One is that short form. Second, they're going to want the tax ID. So those you should all do in that first week and a half.
Okay. And are there certain situations where you need the original will versus a copy?
Kevin, that's a phenomenal question. It's extraordinarily important that the original be maintained. New Jersey arguably has the easiest probate state in the country. As I indicated, when somebody passes away in the state of New Jersey, the executor, without even the need of an attorney, can go to the county surrogate in which a person resided, the deceased resided when they passed away, and they'll just have to bring the will, the death certificate, that information we just discussed that the surrogate will use to complete the intake forms that they have. And the filing fee is about $150, $175, give or take. The appointment takes about 20 minutes tops. It's really that fast and that easy. And that's what you can do 10 days after death if you have the original will. Now, in New Jersey, not all states allow for this, but in New Jersey, if you cannot find the original will, the executor can get a photocopy of the will admitted to probate. However, that has to go through the Superior Court because the surrogate does not have the authority to admit a photocopy. And at that point, it has to go through a court action, which, if you're lucky, is a few $1,000s, not 150, 175. And it's going to take a few months to get the court to sign off rather than 10 days for the surrogate. So it's a very important point that you make. And this is something that you probably should know when you execute your documents or have people execute your documents, that you must, A, have your will in a very, very safe place. And secondly, you don't necessarily need to give out copies, but you should let your executor know that they are in charge of the estate and where the original will is kept.
Yeah. Just let people know where it is.
Mm-hmm.
Yeah. Mm-hmm. So, okay, once the will's probated, what immediate responsibilities fall on the executor?
So at that point, you have to first marshal the assets. You want to be able to get an inventory of the assets that the individual owned at the time of their death. And if you, to the extent possible, you're going to want to go and contacting the fiduciary of those institutions and obtaining what I refer to as date of death values. And secondly, obviously, to the extent possible, having the assets titled in the from the name of the deceased into the name of the estate. Now, as I said, to the extent possible, the reason I say that is that if there is checking, banking accounts of other sorts, brokerage accounts, uh, those are things that you're going to want to change. Now, if you have real estate, you're not going to change the deed. Really, what will happen, quite frankly, is that when it's time to sell the property, there's a mechanism by which you can just merely execute a deed from the estate, in which you recall in the description of the deed when somebody passed away that previously owned it. And the other thing, of course, you don't change is anything that has a beneficiary designation. As the executor, you really don't have any control over assets such as IRAs, other forms of retirement plans, annuities, and life insurance because they'll pass outside of probate to whoever the named beneficiary is. However, you do have a responsibility if you have sole access to the individual's house, for example, or their living spot if they were renting, say, for an apartment, to make sure that the assets are directed to the people that are entitled to receive them. So if there are folks that are supposed to get the IRA, your obligation is to say, look, here's a copy of the death certificate, and here's some copies of the paperwork that you need in order to make the claim. You don't have the authority to do it, but as a decent human being as well as a ethical executor, it's your responsibility to make sure that the people that are inheriting outside the will are provided with the documentation that allows them to do so.
Okay. All right. And are there any deadlines in those first 30 days that people tend to miss or don't necessarily realize even exist?
Unfortunately, there are some deadlines, but in New Jersey, it's not too bad. I mean,
Okay.
the deadlines that pop up is that when you file a will for probate, you have 60 days after will is admitted to probate to send out that notice of probate. And then the other deadlines the other main deadline in New Jersey that affects all states is the time in which creditors must file claims. Up until 2005, if somebody passed away, the executor had an affirmative obligation to file what's called a notice to bar claims. So you would send a notice to anybody that you thought might be a creditor of an estate, as well as publish in the newspaper an advertisement that said, hey, if I'm the executor of the estate of John Jones, and if you think John owns some money, you've got until Y date in order to file what's called a proof of claim with the county surrogate, and that which has to also be served upon the executor. Now, because people, and this is not a bad area of doing some more on their own, often overlook, this particular requirement, or things got a little bit too complicated. What the law provided for when we incorporated the Uniform Probate Code into our statute back in late 2004, early 2005, was that we're shifting the burden from the executor to the creditors to file claims. So nowadays, the creditors have to file claims within 9 months, but it's 9 months instead of 6. We're giving them an extra 3 months to get that done, and so it's no longer the burden of the executor themselves. But the thought process that if somebody owes you money and you haven't been getting a payment for a few months and nobody's responding to your letters, that maybe the person's passed on, you should check, and the companies have a better ability to do that. The reason that's important, also for that 9 months to elapse, is, let's say, for example, you're the executor of an estate, and Kevin, you're a beneficiary, and I give you all let's say you're the sole beneficiary, I give you all your money, 4 or 5 months after the decedent passed away, and a bill comes out, and I get served a copy of that bill within that 9-month period. I'm personally liable to make sure that the bill is paid. So after 9 months, under a normal statute of limitations, which for many collections is about 6 years, after any default on the collection, a creditor could still assert a claim, but they can't go after the executor individually. So that's the other one. The other deadlines are the tax deadlines. Just because somebody passed away, the IRS and the state of New Jersey don't see that as an excuse to not pay your income tax or file your tax return. So the executor has to step into the deceased person's shoes and make sure that by the following April 15th, or if they want to get the extension October 15th, they have to file what's referred to as the final Form 1040 at both the federal and state level if they're due. And also, because I mentioned earlier, when somebody's passed away, their tax ID number, i.e. their Social Security number, has to get replaced by a tax ID number for the estate. There's a form called a 1041, which is basically the business equivalent of an individual return, and an estate is considered a form of a business, so you have to make sure those returns are filed as well. Those are the basic ones that affect all estates. Now, on top of that, if there is federal estate tax or New Jersey estate tax, New Jersey inheritance tax, those returns have to be filed within prescribed time periods. Now, the federal estate tax return is due 9 months after day of death. You and I don't know too many people, I don't think you and I know too many people that fall into that category, because right now you have to have more than $13,980,000. I know
I'm going through my Rolodex of people I know, and I'm not getting there, Tom. Not getting there.
I have to tell you one thing that's kind of still, I'll go like, continuing education conferences, and, there's like some guys on the panel be talking like folks like that walk into their office, every day. And, quite frankly, when they're doing that, they ought to just, step up in the middle of the conference and just say to everybody, and I just caught a fish this big. But every so often we do get those.
Sure.
The other is the New Jersey estate tax was repealed back in 2018, but we do have an inheritance tax that affects estates when the beneficiaries are distant relatives and friends. So let me make that definition clear. In New Jersey, there's no inheritance tax imposed if the beneficiaries are parents, spouses, children, grandchildren, and any other lineal descendant, which probably covers the vast majority of estates. Also, no inheritance tax is due if a charity, for example, is the beneficiary. But when we're talking about brothers and sisters, aunts and uncles, and more remote relatives and other individuals, an inheritance tax return is due, and that's due 8 months after date of death. So one thing that you really make a great point about, Kevin, is that when you sit down initially with a client to go over, as the executor, their responsibilities, you need to make a checklist at that initial meeting. So, one thing I've always told people is, feel free, go ahead and get the will probated on your own, but let's set the time in the first couple of weeks after somebody dies to go over all the things that need to happen. Because sometimes there are other issues that are more time sensitive. For example, if the person owns a house, we want to make sure that that is secure, that people can't be running in and out of it. Technically, you don't have the authority to act on behalf of the estate until that 10-day period elapses and the will gets submitted to probate, but the law has always recognized common sense in certain areas, and if somebody passed away, we're not sure about the number of keys that may be floating out there, it's not inappropriate to have a locksmith come and change the lock to make sure that any particular valuables and personal effects are not raided in the initial weeks after somebody's passed away.
That's an interesting one that I bet not a lot of people think about.
Um, well, they don't think about it in the right way. The problem is a lot of times what people do is they just pop on in and they just take the personal effects anyway. They forget that you really have to go to the probate to have the authority to do it. 95% of the time it's not an issue. And
Right.
I remember once saying I thought one of the most dysfunctional families that I ever had, and it's actually up until 2020, they were known as the family that created the worst probate litigation in Burlington County, New Jersey. But those 7 people, after mom died, somehow miraculously were able to get together a few nights after she passed away and divide all the personal effects. Then, of course, they went back to court a few days after the funeral and started tearing each other apart like a piece of chicken again. So, but some people will just distribute them anyway. And sometimes people do that not to be disrespectful or disrespectful of the law, but a lot of times, you have a case where somebody passes away and some of the family members are coming in from out of state. And, what are you going to do? Tell somebody, I'm sorry, John. I know that, grandma wanted mom wanted you to have these particular items, but you're going to have to come back in a few weeks to get those. It's just, so I guess we would call it in the church community a venial sin. So
When someone lives out of state and is the executor, does that make things more complicated?
I think because of the computer age, not so much
Yeah.
as much as it used to. I mean, yeah, years ago, Kevin, if you and I were sitting down and you were saying, I need to set up my will, who should I name? You could have somebody anywhere, but if you had somebody that was close by, I would always look at that as a bit of a tiebreaker. However, nowadays, really with the exception of the papers that you need to file through probate, which you can actually execute remotely and just use that thing called overnight mail or certified mail, if not snail mail, to get to the surrogate. You can do it that way. And then the other is and also with the exception of a deed, to convey real estate, virtually everything now is done by Adobe Sign or DocuSign. And it doesn't matter whether you're doing that sitting at your house in Cherry Hill, New Jersey or Honolulu, Hawaii. So proximity is not the big deal it used to be. The only thing I've done in getting involved with the probate process is, for example, right now, I have a longtime client who passed away, and their son lives in the Midwest. It doesn't make sense for him to get on a plane to go to the surrogate's court, so I sent the original will and a certified copy of the death certificate to the surrogate. In turn, what they'll do is they'll email me the qualification forms that need to be signed, which I'll coordinate with my client to get signed, and those will get sent back to the surrogate, and within a few days, the short certificates will be released. So it takes a few extra days to do it that way. On the other hand, it's much more pragmatic than, an extra plane trip, I guess. So
Yeah, absolutely. Absolutely. All right. Well, interesting stuff. This is an interesting process, but the way you described it in this kind of 30-day episode is it's not quite as daunting as it might seem as long if you can stay on schedule and sort of break it up into parts.
yeah, the only thing you probably should do is assess at the initial meeting with a client liquidity needs, and that usually falls into 2 categories. One, bills that need to get paid sooner rather than later. Certainly, you want to make sure if there's a house that the utilities are being paid. If there is any outstanding obligations, that you at least notify the creditor. For example, if somebody has to pay the funeral or has to pay some outstanding medical bills, you want to make sure, if you're waiting a couple weeks to get those short certificates and access to the funds, that contact the creditor and say, look, mom died, we're in the process of becoming the executor, and we'll get the payment out to you shortly. But you want to make sure that, because it is easy to get qualified in New Jersey, that you pay things as quickly as possible. I tell people not to stress too much. I mean, let's face it, when somebody passes away, we're not really worried about the credit rating anymore. So, but to do that, and also if there's any survivor that relies upon the deceased for support, and that's usually sometimes a surviving spouse. So you do want to make sure there's some liquidity to take care of the needs of the surviving spouse from the outset. You're not going to tell that individual that they have to wait until the administration of the estate is complete, and sorry, you're not going to get your rent paid or food on your table between now and then. So
Yeah.
that's the other thing that you really want to sit down. So I think your key takeaway for what you do in the 30 days, make sure you get the will admitted to probate, secure the real estate that the person may be living in, find out what the obligations of the estate are, as well as the assets, and then have a meeting with a trusted professional to make sure that you identify what steps need to be taken to make sure that the estate is administered properly.
Yeah, I think that's great advice. I think that it's definitely when you put it all together like that, it sounds doable, whereas it can be definitely overwhelming for people for sure. All right, well that's it for today's episode of The Estate Blueprint with attorney Thomas D. Begley III. To learn more about Tom's work in estate planning, probate, and trust administration, visit begley3law.com. That's the number 3. You'll find resources to help you protect your assets and plan with confidence, and make sure that you can handle all of the things like that we talked about if you get named executor. Thanks for listening. Don't forget to subscribe and review our channel. We very much appreciate it. Thomas, it's really good to see you again. Thanks so much.
Take care, Kevin.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.